Your divorce doesn't have to be like a divorce in the movies. In fact, you probably don't want it to be. You've got a lot of options for divorce, but most people don't really fully know what those options entail. So that's what we're going to talk about today on today's divorce family lawyer Q&A. Joining me for this conversation is Max Emmer. He is the owner, attorney, and counselor at Emmer Law in Bloomfield Hills. Max, thank you so much for being here to talk about this with us.
Thanks, Rachel. Happy to be here. While many don't think it is an exciting topic, you and I think it is, and I think there's a lot we can provide to people out there who are either in this difficult process or contemplating entering it. And I'm happy to provide whatever insights or information I can.
Awesome. Well, I think we should just start with these choices because, we've talked about this before, you and I think it is so true that most people have this mental image of what divorce is, and it's ugly and it's expensive and it happens in court. Tell us a little bit, especially in Michigan, what are your choices? What can you do besides just go to court and have a TV style divorce?
Great. And I think you're absolutely right. I think older people think of the Michael Douglas, Danny DeVito movie War of the Roses. People more recently think of Marriage Story on Netflix and everything in between. And I think a lot of us lawyers and the media in general are doing a disservice to the population who are in or contemplating divorce, because the only reality most people think there is this scorched earth, knock down, draw out traditional litigation. And for many years, that was the case. It was file your complaint, file an answer, send some nasty letters, file some motions, do interrogatories, do subpoenas, maybe do a deposition, mediate it, settle it, or go to trial. And that is so expensive, both financially, emotional capital, you name it, and completely unnecessary, and I would say over 90% of cases. And I think nowadays, especially with practitioners like myself and you and others who really want to provide different options and avenues for divorce and these new family dynamics, it's encouraging. There is something called collaborative divorce, which I'm a certified practitioner. Collaborative divorce is a team approach that takes place mostly out of court that couples a financial neutral, mental health professionals when necessary for custody and parenting time issues, as well as collaboratively trained lawyers to create a team-focused environment to create the most efficient and specialized and customized divorce agreement for you and your partner to move on for the rest of your life. Because as I always stress to clients, when you go scorched earth litigation, unless it's a 2-year marriage with no children, your lawyer and you aren't thinking about the future. The day you leave my office with your divorce decree, you still, if you have kids, you have to coexist with that person for the next 10, 15, 30, 50 years if you want to go to weddings and graduations. And I think about how can we expect to go nuclear on people and then reset to say, well, I literally just called you every horrible name in court. I bashed you in the public record. I tried to hose you financially, and now the lawyers are gone, but we have to co-parent our children and sit at graduation dinners and sit at weddings. And people don't have the foresight to think that way during a nuclear divorce. And I think my job, your job, and lawyers who are trying to bring a little more enlightenment to the process need to remind people of that fact. And so collaborative divorce is one option that we'll talk about another way. Some parties directly negotiate where if it's not a complicated divorce, they can basically split up what, split up who, and then either memorialize the judgment themselves or have a lawyer do it. You could also go to mediation directly and try to resolve things with a third-party private neutral mediator. I offer also what's called limited scope, which is for people who can't afford or don't need an entire attorney process, but might just want some help with a consultation or to prepare a complaint or to memorialize their judgment. There are a lot of alternatives than just saying, here's my $5,000 retainer, bill me 40 grand, and let's make each other's lives miserable when really the only person who wins there is the lawyer. So I'm excited to try and bring awareness about those options. I'm not naive enough to think that traditional litigation is going to go by the wayside. Many people want it. Some people need it. And the old guard and many lawyers still believe it's the only way. But I'm hopeful with conversations like these, we can bring a little more education and awareness.
Yeah, I love that. I mean, let's give people a little perspective, Max. Like, how many cases do you think, in your experience, actually go to be decided by a judge? Like, how many divorces?
Less than 0.5%. So statistically in the United States, entire civil litigation, not just family, less than 1% of cases go to trial. I would say family law, trial is hard to say because you could have an evidentiary hearing for the front of the court. There's a lot of things we call trial, but are not these divorce trials, but less than 0.5%. And I think people need to realize your best case at trial is you're going to spend tens of thousands of dollars of attorney fees, probably 9 to 12 months preparing, getting dragged through the mud, only to go to court where the judge most likely wants to say 50-50, absent extraordinary proof or circumstances. So if we think about a divorce, if we think about this as the baseline, most divorces are 50-50. If you have a great lawyer, some circumstances, maybe you go a couple degrees that way, maybe you go a couple degrees that way. But to think that you're going to go from 0 to 180 one way or the other is just so unrealistic. And I don't want clients to think that's going to happen. And that's why such a big part of my job is managing expectations. If I come across a client who is incredibly litigious, wants blood, and I don't necessarily agree, and we're at an impasse, I'll refer them to someone else, because while I'm in the business of making money, I know my skill set, I know my experience, and I know my personality, and they're going to want someone who is just flesh eating and frothing at the mouth. And I just think it's kind of a big waste of time in a lot of cases. And I'd rather apprise them of the realities of the situation and put them in the hands of someone better suited. But to circle back, most things do not go to trial. Most cases are either resolved directly between the lawyers or at mediation. It's very rare, either extraordinary circumstances or just the parties are just so entrenched and they have gone so scorched earth on one another that they can't even contemplate settling. But as I've said, at the end of the day, the people who really win there is the lawyer, because even if you get to trial and you think you won, you really probably haven't.
Well, I mean, you're still settling. The judge just decides how you're settling instead of you deciding how you're settling, right?
Right. And at the end of the day, right. And at the end of the day, all the judge is doing is applying the law to the facts, which is what I do and what a mediator does. So between myself, the mediator, and if you're before a referee, you're getting 3 different people in your ear telling you what's probably going to happen. It would be very rare for your attorney to say X is going to happen, the mediator say X is going to happen, the friend of the court to say X is going to happen, and then the judge says, screw X, I'm ruling Z. That would be very unusual. And so I say a lot of time, trial is people paying for the privilege to hear the same result, which to me, that's not how I would spend my money. But if there's one thing I've learned in law and business, I'm not arrogant enough nor wise enough to know how people wish to spend their money, even if we might not think it's a wise use.
Right. Well, let's lay out the options, right? You talked about there's collaborative divorce, there's more traditional mediation, there's direct negotiation, which is that just no lawyers at all? It's just me and my husband.
So you guys could do that. I mean, most cases, if it isn't really complicated, and I probably shouldn't say this for business purposes, a lot of people do and could negotiate the terms of their judgment. Now, it is a complicated process. If the paperwork and timing is not completed properly, your divorce will not be entered. So I do recommend at least consulting with a lawyer, and that's where we get into limited scope. Maybe having an hour with me saying, hey, this is what your timeline, this is the statutory waiting period, or hey, this is how you file a proper complaint, or this is what must be in your judgment. But direct negotiation is if Steve and Sarah say, hey, we don't have kids, or hey, we do have a kid, we want 50-50 parenting time, we're going to mutually agree on a flexible schedule, we're going to be joint physical and legal custodians, we're going to split the equity in the house 50-50, and we're going to split our investment account 50-50. Then those people, I mean, they really could either use a court-provided form or just say, hey, Max, or hey, whoever other attorney, here's our agreement. Please memorialize this.
Okay.
So that's direct mediation. Collaborative divorce, and I will preface, I am no expert. I am new to it. In Metro Detroit, there are anywhere from about 15 to 25 collaboratively trained lawyers. And in order to gain certification, you have to take a training with the International Academy of Collaborative Professionals. And what it is a bar of lawyers who see divorce differently and want to make a more civil and more holistic process.
Okay.
And basically how a collaborative divorce would work is, let's say someone sees my website or this video and they say, hey, Max, I'm not confrontational. I'm really interested in collaborative. We would have a meeting. If they retain me, I would send a letter to their current spouse saying, hi, my name is Max Emmer. I'm a family lawyer. I provide collaborative divorce options. Here's the benefits. Your husband is interested. These are 3 collaborative lawyers who either I work really well with, which benefits you, or I think are good fits for you. Now that person can disregard my letter. She can go interview those collaborative lawyers and say she doesn't want to do collaborative. Or if she wants to, for the sake of this example, let's say she wants to do collaborative. She's hired a collaborative lawyer. I'm a collaborative lawyer. The next step is we have the clients sign what's called a participation agreement. And the 2 most unique parts of this compared to traditional litigation are, 1, if they want to end the collaborative process and go to court, the lawyers, the financial neutral, and the mental health counselor can no longer work for them. They are out of the case. We can no longer help you. And second, if one of the parties ends the collaborative process, there is a statutory and mandatory 30-day cooling off period, absent things like violence or abuse, to file in court. That cooling off period is usually hoped for people to kind of get their senses back and come back to the process. But it's a process that empowers the client, lets the client be the driver of the process and the settlement, and lets them make more creative solutions with the team than being in the strict deadlines and guidelines of court. The biggest advantage, too, for a lot of people who are nervous about court is we don't need to file a complaint. We don't have court deadlines. Once we come to an agreement and prepare a divorce decree or judgment in collaborative, we file a joint complaint for divorce with a form that says this is collaborative. We get any statutory waiting period waived, and then we enter the divorce and move on.
And so you can really skip court. You can skip waiting. If you do collaborative, you can make your agreement, make your settlement, and be done with it. And really
pretty much. Exactly. So in the state of Michigan, if you're in court, rather, any divorce, if you have no minor children, there's a 60-day statutory waiting period. Okay. And if you have minor children, it's 6 months. But if you come to a collaborative agreement, we can file a waiver with it. And most judges will waive that time period, especially since they see the parties negotiated collaboratively and in good faith. So is it for everyone? No. But it's an option that I think many people who don't want to go knock down, drag out, who are fearful of court and the stress and anxiety of going to court and the deadlines and motion practice discovery therein, have at their disposal. And in Metro Detroit, I know all of the lawyers were also part of a statewide Michigan pod and bar. We have regular events, and it really benefits the client because all of us pretty much know and work together well, which does make things more efficient because we're not fighting tooth and nail on every disclosure. We're not filing motions to compel every week. And we're really trying to work directly to say, hey, Steve and Sarah, these are your options. Here are guidelines. What works best for the 2 of you and your family? Let's come up together with a settlement that universally looks as pleasing as possible to you both, so you can move on feeling happier and feeling like you had a say in the process. Whereas many people who go to court or mediation feel like they're just getting railroaded by the lawyers and the judge. That's collaborative. It's becoming a growing trend. There are lawyers in Metro Detroit who no longer take traditional litigation cases. Wow. I'm not quite there yet, but for lawyers who like to be problem solvers and like to be creative solution makers, it's a really interesting landscape and one that I'm excited to be a part of.
Can you speak a little, Max, to the expense of it? Because it is a lot of people, right? There's two lawyers, there's a financial advisor, there's maybe a mental health coach.
Absolutely. That's the first thing. When I had a number of lawyers imploring me saying, Max, your personality and practice would fit so well into this. And at every turn, even in my training, I would say, this all sounds hunky-dory, but who's paying for everyone? Because absolutely, like, I'm not sugarcoating it. Sure, there are expenses, but there are a couple ways that there is significant cost savings. One is that the collaborative process mandates voluntary disclosures of financials and information. So whereas in court, your lawyer might be filing motions and interrogatories and subpoenas and all of that, spending thousands and thousands or tens of thousands of dollars in discovery.
Just trying to see what the financials are.
Just trying to get the information. Okay. We are contractually obligating to get that information to the lawyers and the financial neutral as quickly as possible with no delay or intervention. That saves a lot of time and money. The other thing, too, is where in a traditional case, and I'm the first to admit, I am not a financial guru, I'm not an accountant, it takes me a long time to delve through complicated financials. Whereas in a normal litigation case, you're each paying $300 an hour, whatever the hourly rate of each lawyer to go through your financials. In our collaborative cases, we are sending you to the financial neutral and you're splitting that lesser rate. So instead of in traditional litigation, let's say you're spending $600 an hour for two lawyers to go over financials, you're splitting $150 an hour for the financial neutral to do so. So that's a 400% savings. And finally, we can make the team as small or big as you want. Sure, in an ideal world, if it needs it, do we have two collaborative lawyers, a mental health coach, and a financial? Yes. But if someone wants to do collaborative but can't afford that or doesn't need that, we're not going to force it upon them. We do cases all the time, just two lawyers. We do all the time where we have a financial neutral. And if you need a custody person, the benefit of that is just like the financial in that you're not paying two lawyers to bicker over parenting time and custody. You're paying someone about half of our rate, split down the middle, to help you with that. So it's more a la carte services.
Yeah.
And in addition to the potential for cost savings, it's a lot more efficient. When you're filing motions through court and subpoenas and interrogatories, you know, a party has 28 days to answer discovery. Subpoenas get 14 days, lots of communication and correspondence in between.
Right?
So it really can stretch out. So it's not always going to be cheaper, but you will have more control of the process. It very well might be more efficient. And you can feel like you're in control instead of your lawyer, which I think a lot of people might not think they want that. But at the end of the day, this is their life and this is their future. And sophisticated or not, people should be the drivers of their own future.
There's just such a mindset shift around it that makes so much sense to me because, what you're saying that whether, even if it goes the most contested, scorched earth kind of divorce in front of a judge, it's probably going to end up about 50-50. Like that's where we're going.
Or a couple percentages right or left.
Yeah.
Again, if a parent is absent for years or in prison or there's abuse or there's drugs, yes, are we talking about sole custody situation? But if you have two run-of-the-mill parents and cases, we're really not deviating much.
Yeah, so in that traditional litigation, you've got two lawyers fighting tooth and nail for every percent one way or the other. And it sounds like in collaborative, it's everyone sitting down saying, okay, we all know this is going to go more or less 50-50. How do we make this? It's like everyone's on the same team trying to get to a result that's the least painful for both parties and the best for the kids, really.
Well, and it's so you put it. We call it a paradigm shift, which is not always easy, but you nailed it on the head. It's a team. One of my mentors in collaborative always says, I am not opposing counsel. I am the other party's counsel, or I am co-counsel, even if you will. There is no opposition. There have been collaborative cases where one side ends up getting along better with their spouse's attorney than their own, which would be unthinkable. But the goal is, and the other thing in collaborative, no one is trying to screw the other. There are required disclosures. There is a sort of duty of care. Whereas in litigation, if you miss a deadline by 1 minute or you screw something up, my job is to destroy you for that, which, look, if there's an egregious error to the benefit of my client, I have the obligation to seize on that. But also a lot of it won't change the result or outcome at the end of the day. And doing so merely just ratchets, costs and inflation.
The emotional costs, right? And the impact later, like you said, when they meet at their kid's wedding in 20 years, are they still going to
Right. It's the pettiness. And I never blame a client for that loss of rational thought or pettiness, because you're thrust into this fight or flight mode. It would be against human nature not to feel that way. But if they could remove themselves or see it how I see it or you see it, you could give that advice and counsel to say, this is not in your best interest. I like to eat. It's like, yeah, is that chocolate fudge sundae going to taste great at 11 p.m.? Yeah, it's going to taste amazing. Is it going to be good in the long run? Probably not. But I think having other options allows both the lawyer as well as the client to take a more large world view to really look at what are my options and what's going to serve myself, my child, and my ex best. Because I don't know anyone who in 15 years wants to be sitting at table 9 versus table 30 at their kid's wedding, or who wants to not be able to sit in the same room. It happens a lot. Yep. It's the reality, but you have to be a pretty hateful or harmed individual to want such a bifurcated, difficult life for your family and your kids.
I mean, it really sounds like traditional litigation, in some ways kind of feeds and heightens the emotional distress that people are already in. And collaborative gives you an opportunity to kind of take a breath from, like, it's trying to dampen a little bit some of that emotional.
I think that's a great comparison.
Yeah. I feel like we could talk about collaborative all day because it sounds amazing to me, but I want to talk a little bit about the limited scope, because that's so interesting and new to me. Tell us about limited scope representation in Michigan and what that means for people.
So in the state of Michigan, a few years back, I believe it was 2019, the Michigan courts and the legislature made a public policy and legal decision that legal assistance and counsel should be both more accessible and more flexible. Okay. In reality, whether you're talking about family law or any practice, if you don't have that $3,000, $5,000, $10,000 for the retainer, you're really not going to get in the door of a lawyer. Mm. And that's not to say that that's going away by any means, but limited scope, or what we also call unbundled service offerings, makes it so clients and people have more access to legal assistance and guidance. And I'll give you an example. I had a client recently whose girlfriend needed a name change. Now, most lawyers would be like, oh, I'll charge you $1,500 or $2,000 or whatever. I won't even take it. She needed an hour of my time just to figure out the paperwork, talk her through the process, and answer any questions. Through limited scope, I met with her for an hour for $250. No retainer, no requirement. Whatever you need, I'm happy to do. And I also told her, if you need me in the future, we can do it a la carte. We can do it as needed by the hour.
Yeah.
Same thing for a divorce. I've had clients, a lot of family lawyers offer a free 30-minute or a 60-minute consult. And as much as I want to give time and information, I'm still running a business. So I can't give a 2-hour consult. But what I can do is, say you call me and say, hey, Max, I don't know if I need a lawyer for everything, but I have a little more. What do I do between $0 and $3,000 plus your hourly? I can say, well, Rachael, let's book an hour for $250. You ask me any question under the sun. We can talk whatever you need. If you need more, great. If you want me to help prepare your complaint, I'll charge you X. If you want me to have a Zoom conference with you and your partner to figure out the terms of your judgment of divorce, I'll charge you Y. If you want me to prepare the judgment, I'll charge you Z. And if you need me to appear at a hearing, I can charge you whatever.
It's like I can pick and choose what I need.
Offering a la carte services. And many people, I think, would like that because, it's funny. I compared it when we were talking. Options, some people are paralyzed by options. But a lot of people like options. And I compare it to, let's say your knee is bothering you and you go to the doctor and he says amputation or major transplant or major reconstruction. And you're like, holy shit, pardon my French. But wouldn't you feel more comfortable and encouraged if the doctor said, hey, Rachel, yes, the most serious option is significant surgery. But before we get there, we can do physical therapy. We can do steroid medication. We can do an injection. There are options to get you through this process. And it's up to you to determine what you need and what is best for you. And so my goal, as well as the other lawyers in our area who are offering this, are to offer more specialized services to people at an affordable rate. And I think, sure, will it beget business? By some people might start off with one thing and then want us to do the whole case, sure. But I bill by the hour and time, and I am happy to help someone on whatever basis they need me. And a lot of lawyers may not be interested in that, and that's totally fine. I understand it. But I think it's a way for me to differentiate myself and to offer people a service that will benefit them.
Yeah, no, I mean, it sounds so empowering too, because I think you come into divorce, right? And there's so much going on emotionally and it's all really overwhelming and you don't really know anything except what you've seen on TV or what you've heard from your friend's nightmare divorce. And to be able to just come in and say, okay, I can, sit down with Max for an hour and talk it all out and find out actually what I do or don't need. And that doesn't have to cost me $3,000, $5,000 just to even know, right?
Right. Well, it's less of a commitment. I always say I've had clients via one phone call or one quick meeting sign up with me. And while I appreciate that sense of likability and encouraged by them signing up, it is a big decision. And I know personally, I come from a long line of salesmen in a sales family. ABC, always be closing Glengarry Glen Ross. My boss has always closed the person in the room. Honestly, when I give a significant consult, I will tell most clients, unless like their wife is already filed, they know they're going to need a lawyer or whatever. If they're kind of thinking about it on the fence or anything, I say, look, what we've talked about is massive. We have had an emotionally charged and fraught conversation and consult. Take a night or two, digest our conversation, think about what you want and need, and then let me know what you want to do. And sure, could I probably sign up a few of those people when I let them go out the door? Sure. But I think by giving them that opportunity to take a beat, they're more comfortable. If they sign up with me, they're going to be easier to manage and have a better understanding of my work and my philosophy. And I think we're going to have a better client and trust relationship. And that's a personal style of mine.
Yeah. I mean, what I'm hearing from you, Max, is that you're interested in the person and the experience they're going through. And it sounds like there's, been maybe in the past, and I'm sure still to some extent, this like cutthroat family law, divorce lawyer approach in the world that is about making money and winning and getting the most. And what I'm hearing from you is a shift towards, let's help people through what's a really difficult time. There's no winning, there's no losing. Like this is challenging no matter what. Nobody's going to come out of this being like, woohoo, want to do that again. So let's treat them like people and care about what they're going through and offer them. It sounds like you're talking about more of a service-based approach to family law as opposed to a cutthroat money making.
Absolutely. I think that's right. And I'm sure many lawyers will think it's naivete or arrogant or both. And it really isn't. I just think it's my personality and my work style. I always say, I have a big, outgoing, gregarious, and at times obnoxious personality. I can holler and write a nasty letter and do that with the best of them. But I just think it's unnecessary most of the time. And I think it's draining for everyone involved. And I would rather run my business and help clients and maintain my reputation without that draining mechanism. And if I make a little less or have a client or two less, so be it. I have a video that I just filmed that I will eventually publish that is called The Myth of the Pitbull Family Lawyer.
Okay.
And when I say myth, it's not that it doesn't exist, because boy, it does exist. but it might not need to the extent it has for decades and generations. And while the pit bull might think collaborative is BS, just as the collaborative think the pit bull is out of date or cliche, there's room for everyone because, like the 31 flavors, different people have different personalities and different requirements and what they want in a lawyer, an advisor, and a counselor. And I am happy to tell clients, and have in the past, if we're on a different page from the get-go and you want that nasty pit bull, I'll refer you to someone, or don't hire me. Because the last thing I want is someone to hire me thinking they're going to get A and they get B, and then everyone's disappointed.
Yeah.
I am comfortable enough in myself and my business and my abilities where I value my reputation and my ability to refer people out than to be someone I'm not and fake it when I'm not really into it. And while it is a business, it's handling people at their most tender and their most vulnerable. And I think we need to recognize that and not just pay it lip service. And I do mean that genuinely, because aside from the death of a family member, divorce is probably the most dramatic and emotional process someone will ever experience in their life. And I think when lawyers are described as advisors and counselors, as family lawyers, we are counselors. And a big part of our job, arguably more than most lawyers, is to counsel people legally, but especially emotionally, financially, mental health, well-being wise, because this is a catastrophic shakeup to family unit A and the birth of family unit B. And I think we need to be cognizant of that.
Yeah, I think that's so well said. I spoke to one attorney recently who, just from her personal experience, she lost she was widowed very young and had a friend going through a divorce at the same time. And I was surprised to hear from her, she felt like the divorce was actually harder.
I would believe it. I mean, and we talk about briefly, when I say failure, I don't mean to call people who can't stay married failures, but we are human. If you get married and you take that vow or that oath and that message and you're in front of friends and family on a joyous occasion, no one ever wants to think, wow, in 1 year or 5 years or 50 years, my marriage is going to fail and we're going to end it. No one enters into it wanting to be that person. So it is a period of grieving and mourning, even if you want the divorce, even if you think you're thrilled with the divorce. This most sacred chapter and arrangement in your life is now over, either through your fault or someone's fault or no fault. And that is sad, and that is emotionally crippling. And I think lawyers just think, hey, I'm just going to look at your tax return, file the complaint, move on with your life. My job is so much more than that. I'm on the phone and emailing people all day, way more about emotional issues than I am about legal issues. And I thrive on that because I'm a communicative person who loves learning about people and talking to people. And if that is not you, you do not want to be a family lawyer, because you are not going to be left alone at your nice desk to just read and write all day. You are going to be putting out fire after fire, and then you're going to have to figure out how to deal with a tornado. And then you are going to deal with issues you would have never contemplated.
I mean, I laugh, but it's so true, Max, right? Like, this is such an emotionally heightened time. And there's a quality that, like, I think of as like dirty pain instead of clean pain about divorce, because there's that self-judgment. There's that sense like, oh, I failed at this, or I wasn't enough, or I made these mistakes. Like, I see that in my clients all the time, is that blame and that regret, and it makes all of those other emotions, that grief and that sadness and the loss that's happening, so much harder to deal with, because there's that like quality about it where people have their own inner judgment on what's happening.
Absolutely. And I think one thing, especially you coming from a counseling side, I think the biggest awareness, and it's so hard to make people realize it during the process, but if you can avoid some of that pettiness or some of that just distraught fighting feeling, because I joke, if we were able to let these people see what they are fighting about and doing from a rational third party or quasi third party view, they would think they're absolutely insane. And I don't say that to judge,
but you're
but
in
because
it.
people, just to give a few examples, I have had clients fight over old George Foreman grills. I have had clients fight over broken lawn furniture. I have had clients fight over old school big screen TVs that don't work anymore. I have had clients fight over old holiday ornaments. I have had clients fight over the bed linens of an in-law. And everyone, I don't care if you're a CPA or a plumber or anything in between, people aren't stupid. And they would realize, I am paying my lawyer, my spouse is paying their lawyer, maybe we're paying a mediator. And I always joke back to you are paying almost $1,000 an hour to fight over something with what, $50 or $100 of value. No one would ever do that in a rational mindset, but divorce is not rational. The old paradigm and traditional process forces people into an instinctual fight or flight mode where they can't even see rationality or reality. And one thing,
you're not fighting about the lawn furniture. It's like a matter of life and death, right?
Of course, but
who hurts who.
They're manifesting and putting those decades of hurt feelings onto that
furniture. Yeah.
And in reality, you're not fighting over the rake. You're fighting about your broken marriage. You're fighting about the cheating. You're fighting about the lack of trust.
Whose fault is it? And the traditional litigation just encourages so much.
It incentivizes lawyers. And if I don't want to fight for my client, I'm viewed as a weakling. I am viewed as lesser than. I am viewed by the bar as, this guy can't hack it. Where, not to toot my own horn, but I would hope clients would celebrate that. Because again, at the end of the day, there are things to fight about. Your children, major investments, businesses, homes, family heirlooms, things like that. But when we get down to more mundane items of personal property and things, it just isn't worth it. And I think it does clients a disservice when you either don't have the inclination or don't have the desire to be upfront with them with that. And that's something that I'm hopeful my clients and people I'm in business with appreciate.
Yeah, you can help them see, be like, this isn't actually one of those things. Let's use this energy in areas that are actually important, that mean something for you. Max, this might be a good time to talk about, as we're talking about things and the things that you fight for. What can people expect? You were telling me some things about Michigan child support formulas versus spousal support, and there's some real differences in it. I think most people probably don't know about that. Can you tell us, like, what can I expect? I'm going into this divorce. What can I expect to happen as far as my financial obligations, either to my partner or for child support?
Absolutely, Rachel. I think that's such a good question because, especially if you have minor children, child support is a huge part of any divorce. Yeah. And I'm going to separate child support from what we call alimony or spousal support. So let's talk about child support first. The Michigan child support formula takes in anywhere from 10 to 15 factors and pieces of information from income, number of children, overnights, extracurricular costs, who pays health insurance. And there is a precise formula that the court and the friend of the court will utilize if asked to spit out an exact child support amount.
There's no like creativity in there. It's just, this is how much it is.
Well, correct. So lawyers, we also have a program and we're able to run the formula. So if a client comes into me, within 15 minutes, I can give them a pretty good ballpark of what to expect on child support. Now, is there maneuverability on if your income changes or if overnights change or if you share expenses? Yes. And can you deviate from child support? Sure. But you have to show good reason and good cause. If we do a computation and the child support is Steve paying Sarah $1,100 per month, we would have to show a really good reason on that uniform child support order and judgment why he's only paying $400. So child support is pretty rigid, is a pretty certain calculation that is able to be provided by the court, the friend of the court, and your lawyer. Spousal support, on the other hand, is very different. The Michigan legislature and Michigan family courts do not have a specified spousal support calculation. There are guidelines and there are factors like the length of the marriage, the income of the parties, the education of the parties, the health and status of the parties, and things like that that we can use, but it's not so formulaic. There are two really good rules of thumb to use in Michigan for spousal support. The first is that if your marriage is 4 years or less, you should not expect to pay or receive spousal support. Short marriages generally are not ripe for spousal support claims. The second is if you're in a marriage, say between 5 and 20 years, the other good rule of thumb is to expect it to be 1/3 of the length of marriage. So let's say you were married 15 years and you're getting a divorce and you're going to receive spousal support. About 5 years would be a good starting point to expect. Now, spousal support can be long-term or permanent for a host of reasons. Maybe you were married 35 years. Maybe one party is educated and worked the entire marriage and the other stayed home with the family. Maybe one party is disabled or has a health issue that the other party knows about and they can't work. There are a number of ways spousal support can be long-term or permanent, and spousal support is more negotiable than child support. For instance, we can make spousal support non-modifiable if we want. So let's say I was representing Steve and the guideline calculation was 10 years, $1,000 a month. And Steve says to me, Max, I'm 61. I don't think I'm going to work for 10 more years. I don't want to pay 10 years. Then we might negotiate and say 10 years, $1,000 a month. I'm not a math major, but I think that's $120,000. We might say, okay, Steve is willing to pay you $1,200 a month over 7 years. So spousal support allows for a lot more creativity. Or for instance, say there's $100,000 of equity in the house. We could say, you get all of the equity in the house, then I'm only going to pay 4 years of spousal support. So spousal support, since minor children aren't involved, and frankly, the courts are a little less concerned because at the end of the day, the best interest and welfare and health care of the child are most important, courts allow more leeway for spousal support. So I would say the biggest difference in Michigan and most states between child support and spousal support is one, the rigidity of the calculation, and two, the ability to create creative solutions.
Okay. And I mean, so if say we're in a collaborative divorce, me and my husband, we have a lot of leeway. We could get really creative with spousal support and make all kinds of deals with that and decide what works for us. And that's kind of okay. Child support, if we're not doing a litigated divorce, if we're in collaborative, do we have the freedom to make choices about the child support, or is it pretty?
We're still going to, with respect to child support, we're still going to probably follow the guidelines. Here is the biggest situation where we're able to deviate in child support. I've had calculations for one reason or another, say both parties work and they have equal overnights, but based on a disparity of the parties, there is a significant difference in child support. Sometimes, especially parties who work together and trust each other, they might say, hey, I can pay for John when he's in my care. Steve will pay for John when he's in his care. We don't need that $200 difference. And they might close the gap on child support and say, we don't need this extra disparity because we're both capable of taking care of the child. There's also a lot of cases if both people work where if child support's a pretty marginal amount, we actually will waive child support.
Okay.
So let's say Steve works and makes 90 grand, Sarah works and makes 80 grand, and they both have equal overnights. Steve might owe Sarah $70 a month, maybe less. Especially in collaborative, we might say, hey, paying that $70 is going to be more complicated than it's worth. Let's wipe it. Let's put a deviation saying it's only $70. Both parties are able to provide for the child. However, unlike spousal support, you can never make child support non-modifiable. The parties and the court always have the ability to review and modify child support.
Okay. So we could set an agreement on the spousal support and that's it. We're doing that no matter what.
You can make it non-modifiable, or it can be modifiable where it's able to be reviewed. Whereas child support, I don't care if Steve and Sarah are as comfortable and trust each other wherever, you cannot make child support non-modifiable absent extraordinary circumstances, which I'm not going to get into because I've seen it one time in over several hundred cases, and it was a very unique situation.
Okay. So yeah, child support is
modifiable. It's always open to recalc and review. In the state of Michigan, typically you get a recalculation with the front of the court every 3 years. But if there are annual changes, circumstances, say someone loses their job, someone gets a promotion, the health insurance changes, there can be a review and recalc at any time of child support.
Okay. No, thank you. I think it's so interesting that there's such a difference between spousal and child, but it makes sense because
it makes sense, I think, because one is protecting people who have not reached the age of majority, and one is protecting an adult who's able to enter into contract. And I think the public policy is the court always needs the ability to look out for the best interest of the child, whereas if two consenting adults, especially with the assistance of counsel, should be allowed to enter into contract.
Yeah. Okay. Yeah, that makes a lot of sense. While we're talking about the kids, I'm really curious about custody. And custody, do you see much difference in the outcome for custody with your clients in collaborative divorce versus a more traditional mediation or litigated divorce?
So, Rachel, great question. I actually just was writing an article on this morning. So when we think of custody, there's several components. Custody is an umbrella term. Okay. First is legal custody, which means who is the custodial legal parent for that child? Okay. The default in Michigan courts, as well as every state, is joint custody. Courts and public policy dictates that the best interest of the child and the healthiest children are ones who have healthy relationships with both parents. Yeah. Okay. So we're going to default to joint legal custody unless there's an issue of abuse or abandonment, things like that. So legal custody are things like who decides treatment, healthcare of the child, who decides religious, where does the child live, big things. Physical custody is also like parenting time, whereas where is the child going to live Monday, Tuesday, and Wednesday night, Thursday, Friday, Saturday, and Sunday night? Who's going to pick him up from school? Who's going to take him to his dentist appointment? That is parenting time, more physical custody requirements. And that can also be joint and equal, or it can skew. You know, I have many clients where one party has 5 overnights, one party has 2 overnights, but they're still joint legal custodians. They just have a majority-minority overnight relationship.
Okay, so like they still have the parent
equal decision-making on medical, but one parent, whether it's their schedule or whatever, has more overnights.
Okay, so okay.
So that's kind of custody and parenting time. What was the other thing? Just
if there's a difference in collaborative outcomes around custody, do you feel like there's?
So generally, most cases do end up being joint legal and physical custody, absent a host of reasons that I kind of previously explained. If a parent's kind of abandoned, if they don't have the health or mental well-being to take care of a child, the court is always going to want us to dictate to joint, and that doesn't differ much in collaborative versus court. I think the biggest difference is in collaborative, there's more of an emphasis on creating a livable schedule for parenting time. Because I have clients who will come up with these, forget a spreadsheet, these world map of a schedule saying, well, Steve will pick up Joe at 7:15, but Sarah will pick him up at 7:30 every third Monday. But Steve will pick him up on the fourth Monday at 8:20. And it's like, guys, we don't live in that world.
Your kid doesn't need to live in that world. Your kid
doesn't. And I think collaborative, since we are forward thinking and future looking, we are trying to say, hey, what are livable solutions? Obviously, whatever divorce you get with minor children, I hate judgments that leave terms vague and ambiguous because you're going to be in court every week. I like to say that even though it kind of sucks, mom gets Stephen from Christmas Eve at 5 p.m. till Christmas morning at 10 a.m. and dad gets Christmas Day at 10 a.m. to the 26th. Because if we don't have some clear instructions, people aren't going to act most likely in a reliable and fair way, which is where we get front of the court parenting time complaints getting dragged back into court. And one interesting thing I will stress that many people don't know is if you're already divorced and you have joint custody, but you are dragging each other into court every week, you are filing parenting time complaints every week, the court can strip you of joint custody. The court can tell two adults, you are not equipped and capable to co-parent this child together, and we are going to have a review, and we are going to take custody away from one of you. Now, is that an extreme? Yes.
But
does it
possible.
happen? Absolutely. And I always counsel clients, I'll get calls all the time. Joe was supposed to be here at 5, it's 5:03. I go, look, I understand. I am on time to everything, but it's 3 minutes. Now, if Joe every week is showing up 30 minutes late, that's not okay. But people really need to balance how much they want to follow the letter of the law to the point where am I being unreasonable versus where am I being a human being? One overage, a few minutes every now and again, I don't think you should call your lawyer in front of the court. But at the same time, if your parenting time agreement says dad is supposed to drop Stephen off at your house at 5 p.m. and routinely he's coming at 5:45 or 6 or 7 or not coming, yes, that needs to be addressed, of course.
But it sounds like you're kind of juggling, like, yes, there's extreme cases where that's why you have this specific agreement so that you can enforce it. But if you kind of in the spirit of collaborative, like if you can keep, if you want to keep it in your control between you as the parents, if you can work it out together, because if you keep coming in front of the court over little things over and over,
they're not going to trust you and they're not going to believe in your ability to co-parent.
Yeah.
And I think the person who is wronged always thinks they're going to look good in court. Your parenting time coordinator and your judge is going to think you're annoying. I'm just going to be honest. I had clients who in Michigan and Oakland County in particular, to, I guess, save people money, parents are allowed to file parenting time complaints with a friend of the court. And it's a form, and they send it to their referee's team and their parenting time coordinator. And it can say, John was 11 minutes late, or John didn't let me have my Zoom with my son, or whatever. And I had a couple who would each file 2 or 3 of these every week. And the parenting time coordinator would call me and be like, this is crazy. I'm like, you're telling me? And I go, I counsel them not to do this. And they said, they're not looking good because every time they go to court, the judge or the referee is going to see in their file, why do you have 39 parenting time complaints? And they're like, oh, well, he does this and she does that. And they're going to say, I don't care. Figure it out, or we're going to figure out a different arrangement, because the court does not want the kid to be the tug of war ornament between 2 petty parents.
Yeah. Yeah, because it's the kid who suffers.
It's the kid who suffers. It's the kid's routine is completely thrown askew. It's the kid who's being used as a pawn, and the court and the friend of the court does not want to see that and really won't tolerate it.
Okay. Yeah, I mean, I think, yeah, it's an important thing to be clear about, right? That this isn't in your favor to kind of abuse this system to continue that bitter, petty. I mean, it's kind of like we talked about, right? That emotional piece. It's natural to want to hurt this person.
Oh, of course.
So natural.
Of course.
But it's not helping you.
My office, right. If someone comes into my office cool as a cucumber, I guess I'm impressed, but I'm also a little confused. I never look down on or judge a client for wanting to be vindictive or wanting to get revenge or having those urges. All I try to do is at least counsel them against it when it's not in their interest, and try and help them, see the forest through the trees so they can do what's best for themselves and their family. Because at the end of the day, our goal is not to punish and embarrass your ex. Our goal is to end your marriage with dignity and start your new life and your new chapter and your new family as healthy and happily as we can. And I think that is ignored by lawyers oftentimes and not remembered by clients as well.
I love that, to end your marriage with dignity and move on, move forward. That's
what we're here for. And collaborative lets you do that, I think. Not the litigation. I've had traditional litigation cases where there has been very minimal fighting. That's not to just, cast aspersions on litigation in general. I just think different people have different needs. And I think, conversations like this, and I think putting out content and showcasing oneself to people and clients in the community, give people a sense of if I'm entering this terrible process, what sort of advisor and counselor and ally do I want on my team? Someone might want a hellraiser and a sword thrower. And to them, I can give you 5 great ones in Detroit who will take extraordinary care of you. I can do it if the need be, but I would rather be more of a negotiator, a problem solver, and a counselor, because I really think that's where my strengths and my skills lie. And if I can showcase that in a conversation like this, I'm really happy to do it.
Yeah, Max, this has been incredible. I really think the conversation around options and getting people some clarity on what's realistic and what to expect. And also, I think it's really empowering, right, to have some of these choices.
Absolutely. Unless choice paralyzes you, humans like choices. Humans like options.
Yeah. Max, just the last thing, what's the one thing you'd like to leave people with? What's the piece of advice that you have for somebody entering this process, starting the divorce process?
I think people need to meet more than one lawyer and assess their options, see different styles and different approaches. And I personally believe the best family lawyers are problem solvers who are communicative and forward thinking. And I don't just say that because I think those are my strengths, because there's many better and more seasoned family lawyers than me. But I really think if anyone is watching this video or reading our articles or content, and they are in the market, unfortunately, for a family lawyer, look for lawyers who are communicative, who are problem solvers, and who want to encourage you to look towards your future family and not let you focus on past indiscretions, past hurt feelings, and past mistakes. And that's how I would encourage people to lawyer shop and lawyer search if they're in the situation where they are either entering a divorce, in a divorce, or having issues post-divorce.
That's awesome, Max. It's almost like you have to overcome those, kind of baser instincts, that vindictive, resentful part.
Absolutely.
That kind of, and
we are humans with fight or flight. And again, just like you, when you're counseling someone, I'm sure they reveal, I don't want to say the ugly part of themselves, but the raw part of themselves. And it is not our job to shame them for it. It is just our job to help them counterbalance that.
Yeah, it's like, get that part on your team so that because that part just wants you to feel better, right? That part that's vindictive, that's resentful, that wants to kill your ex. It just wants to do that so you can feel better. So you could give into that part and go down that path, but it doesn't actually help, right? It doesn't actually make your future better. It doesn't help you get where you want to go. So
it just inflames tensions and makes things more toxic. It might give you that, instantaneous dopamine hit, I guess, but when you see your bill and you see how miserable everyone is and your case is dragging out, that dopamine hit for calling your ex an asshole in court, or calling someone, a drunk or a whore or a cheater or whatever, is really going to fall by the wayside. And then you're just going to be left with yourself to pick up the pieces, knowing that all you guys have done is just make it messier.
Yeah, no, I think that's such great advice, right? Is to, when you're looking for your lawyer, look for somebody who's going to encourage you to look ahead, to create the best possible future and the best outcome for yourself, and not kind of give in to the quick fix, the quick dopamine hit. Go for the long term. Going for serotonin.
Exactly. All right. You see, you know better than me. Serotonin, dopamine.
Well, the dopamine's quick. The serotonin will have a longer lasting effect.
It steadies off. Exactly. Well, Rachel, I thank you so much for having me. I think this was great. If you have any other questions, I'm always available. And maybe when people see this, and if they have any more and they want to follow up, they're not sick of my voice and face, we can do it again.
That would be amazing. And Max, we should tell people, I'm going to put your contact information in the description of this video so people can reach out to you. But what's the best way for them to talk to you if they want to consult, if they want to work with you?
Absolutely. So my website is emmerlawplc.com, EMMERLAWPLC.com. My email is max@emmerlawplc.com. You can find me on LinkedIn. My phone number is on my website, 248-859-0015. As I've said the word communicative about 100 times, if there's one thing I am, is communicative and responsive. if you want to get a hold of me, you'll be able to, and I will get back to you quickly. So if people have questions or need my services or want to talk, I'm always available, and it's something I'm passionate about in addition to my profession. So I welcome any inquiries.
Wonderful. Max, we'll put all that information in the video description, and thank you so much. I think this is
Thank you.
really, really helpful, really educational.
Thank you. It was a pleasure.